Okay, so moving on to depositories, and there's been a lot of discussion, obviously, in the industry about the liability provisions of the depository to replace lost assets. But I thought what would be useful to try and talk about the depository implications overall, and to share how we think about them. And I mentioned the fact that obviously AIFMD touches not only hedge funds but long-only funds. So we start from the basic, the long-only funds model. And in an environment, obviously, where there is strict liability on the depository to replace any assets that may be lost, we certainly think that most depositories or their custodian arms are looking through the network to kind of assess the risks of any assets getting lost. Obviously, that takes place in any event as part of any network management sort of function. But I think the standard being raised does cause a thought process around re-evaluating the extent of the network and any specific, particularly market risks where being able to access those assets may be more challenging. For the hedge fund managers in the room, the prime broker model is obviously of particular kind of hot topic, and solutioning the prime broker model and how we are trying to, I suppose our terms of reference on solutioning the prime broker model is to try and achieve the perfect model of our depository obligations over, in terms of protecting our liability over the assets that are held in custody or held specifically for the fund, needs to be kind of squared with the prime broker who has existing operating models using their own network, and that needs to also then be squared against the fund manager who's, particularly if they're used to a Cayman fund, have an existing model today where perhaps the prime broker supports a lot of the operation activity. So I'm not going to, I suppose, give you an answer today on what I think that final model will look like, but achieving that sort of perfecting that model between those three interests, it's quite hard to kind of work through that and try and achieve everybody's outcome. But it's suffice to say there's a lot of work taking place between the depositories and the prime brokers to try and resolve that one. Fund of funds. Again, the depository has an obligation for safekeeping of the fund-to-fund assets, and I think how that is achieved is sort of still somewhat work in progress, very reliant on level 2 to finalise that approach. But for sure there's reference in there to, if there's a controlling interest in a target fund, having to look through. So I think there's more work to be done in terms of looking at the fund-to-fund model to think about whether a depository would have to look through a target fund. Would be different in my experience to the normal fund-to-fund model today, and that would probably be seen more as an activity of the manager. So assets that don't fall in the strict liability net, for example OTC, real estate, private equity, all fall under the depository's obligation to verify for existence and to record keep. And again, there are, I suppose, a number of different ways of achieving that. And those operating models need to be fully defined by the depositories. And I think, I guess it depends. If you have the administrators keep a lot of those records, then that be relied upon. But equally, verifying or the existence of those assets is maybe a challenge, particularly the more esoteric the asset gets. How does the depository verify the existence of that asset? And that's certainly something that we're working our way through. And then finally, and without meaning to understate it, the oversight model. So what I've described is essentially what we would carve out into different parts of our custody world. But there are very specific oversight responsibilities placed on the depository around areas such as cash flow monitoring, and NAV review and investor dealing review. And it can depend on the jurisdiction, the type of models that already exist in jurisdictions as to how easy those responsibilities are to perfect. But there are some challenges there in terms of if depositories putting that operating model in place. There's requirements, for example, in cash flow monitoring around identifying unusual cash flows or exceptional cash flows. And again, I think depositories will have to come to their own determination of how they calibrate those types of events and how they put the triggers in place to identify them. NAV review and investor dealing review, again, it depends on the jurisdiction. Some jurisdictions have this already today, so it's not really a change. But equally, I think it's a challenge, I think, in terms of managers using multiple, say, administrators, if they're all in the depository net. Basically, the depository is going to have to do some form of due diligence on all of those administrators, and that obviously starts to burn the costs equation, unfortunately. And likewise on dealing, again, I think it's the review of that typically that's part of the administration operation as well. Okay, so administrators. The only mention, at least that I found, of administrators in the directive is in the context of the valuation provisions. But as I mentioned, fund administrators essentially act as sort of the back office or part of the back office of fund managers. So if managers have changed responsibilities around reporting to regulators, reporting to investors, specified responsibilities around valuation, that's going to touch the administrator. Equally, the administrators need to recognise that if it doesn't exist today, and this would be a case in a Cayman fund, that a depository is in place and has oversight responsibilities of NAV and dealing. That needs to be thought about, because as an administrator you essentially have two clients now, because you've got the manager, who you already have, so not necessarily a change there, but equally you've got a depository who's got specified responsibilities that it needs to discharge. So therefore it's going to want to understand how it can be satisfied that they conduct their NAV review, how they can review investor dealing. So those are areas I think that administrators, if they're not thinking about, need to think about. I think looking through the typical fund administration services, the mention of the administrator in the directive is in the context of recognising that fund administrators calculate NAV, not necessarily being valuers. But inevitably, if a fund manager has the obligation to put detailed policies, procedures in place, going right down to asset class level, then the administrator really needs to be working closely with their client to understand how that sort of responsibility is going to evolve, because it needs to be, managers need to kind of link to the operating model of the administrator in terms of that discussion. Reporting to regulators, as I mentioned, lots of information going to regulators, assets under management, liquidity, leverage, risk. Administrators hold the official books and records of the fund, so it's more than likely that they're going to be relied upon to certainly provide some of that information as part of the regulatory reporting provision to the manager. That being said, a lot of managers still obviously shadow information, so that maybe that managers will use it as a form of reconciliation to their records. But nonetheless, that needs to be thought about, and I think, to be fair, most of the fund administrators have already had to confront that with Dodd-Frank, so I don't think we'll be necessarily digging up the road again twice on that. And then communications to investors, either via the transfer agency function or the financial statements process. Investors need to be updated on the liquidity and leverage outcome of the fund for the year. So as a basic, that's going to go in the accounts. Don't think that's a big change for fund administrators to accommodate changes to disclosures. But equally, if there's sort of significant changes that investors needed to be alerted to, I think whether they originate directly from the manager or through the transfer agent need to be addressed.